Kenyans can now breathe easy and watch their favorite shows on TV with peace of mind. This is after the Court of Appeal halted the digital migration process that had begun yesterday. Changole has these details.
Better picture quality, more TV choices, better TV access, better viewing pleasure. This is just a few of the benefits the government says the move from analog to digital frequencies would afford Kenyans. But the reality has been anything but that. Instead, many Kenyans have been forced to forego watching their favorite programs entirely once the switch off was effected on the 26th of December 2013 following the ruling by the High Court dismissing a petition by Kenyans, Citizen and NTV to delay the switch. But the media houses moved to the appellate court today, arguing that the digital migration contravenes their constitutional right to broadcast and the people's right to information, and seeking orders halting the move until after their substantive appeal was heard.
Article 33 vests in every Kenyan the constitutional freedom to receive information. The Kenyan people receive information from media houses.
However, opposing counsel argued that the court could not halt the process as it had already begun a day before the appeal was heard and therefore could not be reversed.
You cannot restrain that which is already done.
But the counsel representing the media said the decision taken by the Communication Commission of Kenya to effect the migration was taken with full cognizance of the fact that an appeal had been lodged in the appellate court and was therefore presumptive of the court decision.
The actions by the respondents to switch off consumers was unreasonable. It is against the practice of this honorable court.
You cannot preempt a court process by issuing press statements and minutes before midnight and expect to come here on Friday and say it's a fait accompli. It is not.
In its ruling, the appellate court argued that the matters raised by the three media houses presented grounds for an arguable appeal. The court therefore ordered the Ministry of Information and CCK to halt the switch off from analog to digital broadcasting for 45 days pending a substantive appeal by the three media houses that seeks to reverse the High Court ruling last week.
And we accordingly restrain the second and third respondents from switching off the applicants' analog frequencies, broadcasting spectrums and broadcasting services, and, if already switched off, to reinstate the same pending the hearing and determination of the intended appeal on or before the 6th February 2014. The court will now rise.
The news was well received by the counsel representing the media houses, who said it vindicated them.
The first thing is that the set boxes have to be priced reasonably. The prices are still very high. You remember in other countries like Tanzania, the prices are half what we are getting here.
And to some extent, we have been vindicated because, you know, he refused to give us stay orders on the 23rd when he dismissed the petition. And we had said give us a very temporary short stay. And he didn't, but we've got those orders now from the Court of Appeal.
The appeal will be heard in appellate court from February 6th, after which a decision will be taken on the digital migration process. The government had planned to effect the migration countrywide by mid of 2014, ahead of the global deadline in June 2015. The decision by the appellate court is a welcome one for Kenyans, who will now get to watch their favorite programs at least for the next 45 days. Changole, KTN.